So there are two Second Amendment cases up for Supreme Court consideration next term that have the potential to stop the ATF's current attacks on the Second Amendment. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. So I guess in the intro, two cases challenging the ATF's interpretation of bump stocks as actual machine guns are up for Supreme Court review next term. The cases we'll be talking about in this video are Apashian v. Garland and GOA v. Garland. These two cases were carried over from the Supreme Court's last term and are now two of the only major Second Amendment cases on the Supreme Court's docket for next term. These two cases challenge the ATF's ability to arbitrarily change regulatory definitions in a way that is more akin to them actually creating legislation. These two cases, if taken up by the Supreme Court, have the potential to stop current and future actions by the ATF which violate our Second Amendment rights. Now, some quick background on these cases, how the issues arose, and why these two cases are important not just for bump stocks, but other ATF actions as well. For many years, the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, after an incident in Las Vegas that many of you are aware of, then President Trump decided to arbitrarily have the ATF change the regulatory definition of a machine gun so that bump stocks would be considered to actually be machine guns. This new rule took effect on March of 2019, and therefore under federal law, owners were required to either destroy the devices or to surrender them over to the ATF. This change in definition made possessors of these bump stocks subject to imprisonment of 10 years and also a $250,000 fine if you fail to destroy or to surrender those devices. In the Apashian case, Mr. Apashian purchased a slide fire bump stock before the ATF's final rule was even issued, and again, the ATF had said that prior it was lawful to purchase and possess these items. Then they changed the rule, and all of a sudden his purchase of that slide fire bump stock was then illegal. He then sued the ATF, and now his lawsuit against the ATF has made its way all the way up to the Supreme Court. In response to his lawsuit, the Biden administration also filed a brief to the Supreme Court, arguing that the ATF has appropriately interpreted the term machine gun to encompass devices like bump stocks. The three main arguments the Biden administration makes is that the petitioner has failed to show a likelihood of success on the merits, that there is no division in authority warranting the Supreme Court's review of this case, and also they argue that the question surrounding Chevron deference, which we'll talk about a little bit later, does not need to be reviewed by the Supreme Court. After the Biden administration filed their response, the petitioners then filed their reply. In the reply, they argued that the Supreme Court should review this case to determine if Chevron can be waived, if Chevron applies to criminal statutes, and they also argue that this case is well suited to address this type of issue revolving around what type of discretion should be given to an administrative agency like the ATF. If you're not aware of what Chevron deference refers to, Chevron deference is a term coined after a landmark Supreme Court case referring to the doctrine of judicial deference given to administrative actions. Generally, for an agency to be given Chevron deference, the agency's interpretation of an ambiguous statute must be rational or reasonable. So when a statute has an ambiguous term, the agency responsible for enforcing that statute may be able to determine what the term was intended to mean as long as their interpretation of that ambiguous term is rational or reasonable. In contrast to Chevron deference, there are other rules like the rule of lenity, and the rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous law in a way that is most favorable to the people, not the enforcement agency like the ATF. The interpretation of the definition of machine gun does involve criminal penalties, and therefore the argument is, in this case, that if the term is determined to be ambiguous, then the tie should essentially go to us, the people, and favor should not be given to the ATF. Now, Apashian was originally set to be distributed to the Supreme Court back in December of 2021. However, while we were waiting for the conference by the Supreme Court on that case, the Sixth Circuit issued a ruling in a different bump stock case, and that case is called GOA v. Garland. These cases are similar in nature, but arose out of different plaintiffs in different circuit courts. The Sixth Circuit en banc panel, in reviewing the GOA case, was unable to reach a majority opinion and instead issued a rare 8-8 ruling. This deadlocked ruling in the Sixth Circuit resulted in no precedential appeal court decision, and by default, the lower court's ruling in favor of the ATF had to be affirmed by that deadlocked ruling. Now, after the Sixth Circuit's 8-8 opinion in the GOA case, the Apashian case was removed from conference and has been in limbo ever since. And then the GOA case also made its way up to the Supreme Court, and both of these were kind of on hold together. The idea of some people was that the Supreme Court was waiting for both of these cases to be at the same level, at the same briefing kind of level as well, and then they would distribute it for conference and consider them both in unison. However, these two cases were not decided last term and now are going to carry over into this new Supreme Court term. Last term, we received a ton of landmark Supreme Court decisions, not just in the Second Amendment space. Of course, we got the Bruin decision by the Supreme Court, but we also got some GVRs in the Duncan and A&J RPC magazine ban cases. We got the Bianchi v. Frosch assault weapons ban case, and then we also had the Young v. Hawaii open carry case, all of which were GVR'd after Bruin. But beyond these, we also got other big decisions like in regards to abortion. And then we also had the West Virginia v. EPA decision, which also directly bears on these ATF actions and the questions involved in GOA and Apashian as well. Now, although the EPA case dealt primarily with the EPA as an agency, that case really did have broader implications. Really, that case was about what type of authority do executive agencies have beyond those expressly delegated to them by Congress and legislation. In reaching their decision, Supreme Court said that this case, the EPA case, involved the major question doctrine. Under the major question doctrine, the Supreme Court declared that if an agency seeks to decide an issue of major national significance, its actions must be supported by clear statutory authorization. Now, let me explain why the use of the major question doctrine is very important also for these Second Amendment cases. Currently, the ATF has engaged in various actions claiming that under the vague statutory language of the NFA and GCA, they have the power under Chevron to make whatever rules they want. This includes their actions banning bump stocks, their new rule on frames and receivers, their new rule on pistol braces, which is coming in December, their attacks on rare breed triggers and other force reset triggers, and other actions as well. What the Supreme Court is indicating in the West Virginia case is that agencies will no longer be afforded broad Chevron deference when their actions have vast economic and political significance. Instead, the court is now establishing that if Congress wants to give an administrative agency like the ATF the power to make these types of decisions, it must state that fact very clear and expressly in the statute in which they are granting that authority. So again, they can't do anything beyond what is expressly granted to them by Congress. So with the Supreme Court's last term decisions in Bruin and West Virginia, those have set the foundation for these bump stock cases to lead to the eradication of the ATF's current overreach. So although these two cases were carried over from last term, and although they are kind of going under the radar right now, these two cases really have the potential to completely change the landscape of the Second Amendment and also prevent current and future attacks and actions against our rights to keep and bear arms. And that's a big deal. So although these two cases were carried over from the last Supreme Court term, and although they are kind of going under the radar right now, these two cases really have the potential to completely change the landscape of the Second Amendment and to prevent current and future attacks on our rights to keep and bear arms. So these are cases we will definitely be keeping our eyes on and everybody should know about. If we get any more information, I will let you all know. Also, if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if this video and support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.